Any mention?
Can we crave your Lordship's indulgence to make a mention, my lords, for listing of a motion matter for tomorrow, my lords? These are a batch of writ petitions. What has happened, my lords, is the petitioners before my lords are these gas agencies from Shillong, my lords. Now, as against the Indian Oil Corporation, my lords, when these cylinders are picked up from the plant, there's something called an ERV slip which is signed. Now, this entire process has been completed, my lords, for quite some time. Now, all of a sudden, my lords, we have got some email from their end saying that their records are not available, and as such, they want to make a debit from our account. We produced the
account meaning?
Well, it's from my account. They are saying that since the ERV process is not.
What's ERV?
Well, it's called equipment return vouchers, millets. These are with regard to these gas cylinders, millets. So now this pertains to an earlier period. Now they are saying, millets, that since it is not complete in their records, they will make a debit from our account. Now we produced the relevant, because we have a set of those documents, millets. We've produced it to them. We've gone and met them. Now yesterday, millets, we've received an email saying that yes, millets. They have said that even though we have given you an opportunity, you have neither come nor have you produced the documents. As such,
we get deducted the thing from
they're going to debit it, millets. I'll oblige. We're filing it in the course of the day, millets, so tomorrow.
Any mention?
Very good. Strange. I think first time that there's no mention. Yes.
Lordship,
Spoke too soon.
item number 20, my lord. On the last occasion, this honourable court was pleased to grant us leave to file an additional affidavit, lordship. We are filing in the course of the day, my lord.
No objection, your lordship. I'm appearing for the petition, your lordship.
Item
20, my lord.
Hajong.
Yes, lordship.
Okay. Yes.
Much obliged, lordship.
Supplementary list, item number 1.
Yes.
Please, Your Lordship. Well, the gist of the dispute here is this, Lords, that I have been appointed pursuant to an open tender as an agent of the Jayante Hills Autonomous District Council to manage and operate its forest revenue stations, essentially to collect royalty on any kind of forest produce that is being removed and transited from the territories of the District Council. But an agreement was also executed in my favor. The tenure whereof was about 3 years. Subsequently, I started operating those revenue stations without any complaints whatsoever. Now, it turns out some NGO had filed a complaint against me. An FIR was filed. And on the basis of the FIR, without affording me an opportunity of hearing, and without any sort of a show cause, FIR is not with me, Lords, because we have not received a copy of the FIR. But pursuant to the FIR, Lords, kindly see the clarification that has been issued by the District Council at page 39.
Yes.
This is a clarification dated 16th of July 2025. My lords have it? Let me just read this out. See the subject, my lords. Clarification regarding appointment of council's agent to manage and control the forest revenue station of GHDC. I am directed to invite a reference to the aforementioned subject and to say that the news report has appeared in some section of the media that the so-and-so has lodged an FIR before the Superintendent of Police, East Jayante Hills District, Heriot, against Sri Sevenbon Tang, alleging that he is running the council's forest checkpoints without any authorization from the GHDC. The said allegation is made purportedly on the basis of information obtained by the complainant through the RTI Act 2005. It may be mentioned that the so-and-so white RTI application dated 21/5/25 had sought for information with regard to the appointment of the council's agent to operate the way bridge cum forest checkpoint at Sunapur East Jayante Hills District. In a reply to the said RTI application, it is stated that the GHDC is not operating any way bridge within its jurisdiction. So they've made a distinction between a forest revenue station and a way bridge. There is no forest revenue station classified as weighbridge cum forest checkpoint, and hence no agent is appointed by the JHDC for operation of weighbridge cum forest checkpoint. In fact, the JHDC has established numbers of forest revenue stations under Rule 56 of the so-and-so rules of 1960 and have been operating and managing the same since its inception. However, the council observed that the collection of revenue from the forest revenue stations is excessively low to the extent that the same would not cover up even the salaries of the staff posted at such forest revenue stations. Therefore, the council felt it appropriate that the management of the forest revenue stations be outsourced to private parties in order to enhance the generation of revenue from the same. As such, in exercise of powers under Section 12 of so-and-so Act 1958, the management and control of all forest check stations, revenue stations, is outsourced to private party by way of tender process, and Shri Sevenwan Tang, being the successful tenderer, is appointed as the council's agent to operate these forest revenue stations for a period of 3 years. Furthermore, it is to be noted that the appointed agent has been discharging his duties diligently and has been regularly depositing the quarterly premium amount to the council. The revenue generated and received under his management has shown significant improvement in comparison to previous financial years, thereby contributing to the council's forest revenue system. The allegations leveled by so-and-so are entirely unfounded, misleading, and factually incorrect. It is evident that these claims have been made without any proper verification, factual cross-checking, and research into the actual circumstances and ground realities. Such statements made in the absence of credible evidence and due diligence not only distort the truth but also have the potential to mislead the public and undermine the integrity of a constitutional body. As stated above, the information sought by the so-and-so in their RTI application is specifically with regard to the appointment of agent for operating the weighbridge cum forest checkpoint in Sunapur, and the reply to the same is that the council...
They stand, why have they truncated your...
And you just please notice this, this is a clarification issued on the 16th of July 2025, and please see the impugned order, which is at page 44.
Yes.
So at page 44, I am issued this communication by the Chief Forest Officer, and this is dated 24th of July 2025. Now, Lordship will recall the clarification was issued on the 16th of July. Now, this reads, subject agreement entered into on the 16th of July 2024. With reference to the subject cited above, I am to inform you that due to the objection of different NGOs, which lead to filing the FIR by so-and-so, the Executive Committee JHDC held on 10th July 25. So clarification is issued on the 16th where they sing praises about me, and on 10th July the EC has already taken a decision, has decided to reduce the period of lease as the agent of Forest Revenue Station JHDC from 3 years to 1 year. Now, this is highly unreasonable and unfair.
Yes, Dr. Mozika. How can you sustain this kind of... your term ends in?
Well, it ends in 27, my lord.
So the
3 years.
One. Have you made that NGO a party?
No, my lord, because...
make them parties.
If your lordships direct, we'll make them a party, my lord.
Yes. Anything to say right now?
I'll file affidavit. There is no testimony.
Yes.
It's because there's no formal complaint as such against me.
Not Mr. Senate Counsel for the petitioner. If you notice, Dr. Mozika with so-and-so present on behalf of all the respondents, no further notice with respect to respondents. Stop. The grievance petitioner is that on having entered to agreement by way of open tender for appointment as council's agent stroke lessee for management control of a lessee for a revenue station situated where?
It's at different stations, my lord. Mokindur, Sunapeta, Ratachera, there are about 5 places.
For the revenue stations under the forest, this is called management control of forests and term for collection of revision for collection of forest revenue. So on but we've open tender as a council's agents to lessee for revenue stations to collect
Royalty, my lord.
tolls.
Royalty.
Yes, on forest products. The respondents apparently on a complaint of an NGO. What is this HITOS? What's a full?
So I have that note. Hinuthrep Integrated Territorial
On
Organization.
a complaint of a certain NGO known as H so-and-so, bracket HITO, by the impugn order, has truncated the period of lease from 3 years to 1 year without any opportunity of hearing being given to the writ petitioner. Stop. That the executive committee itself on 16 July 2025 had written to the Superintendent of Police East Jaintia Hills District clarifying the situation that the petitioner was a valid lessee and was discharging the duty diligently. But however, the impugn order dated 24 July 2025 speaks otherwise. Stop. In his view of the matter, a prima facie case has been made out for issuance of interim orders at this stage. Dr. Mbozika, Leonard Counsel for the response 1 to 5, submits that he will obtain instructions and file affidavit. Stop. In this matter, is noted that a confidential body, it appears, has issued the impugn order on the basis of an FER filed by an NGO. Accordingly, for proper adjudication matter, it is deemed necessary that a said NGO, HITO, be adhered as party respondent in the proceedings through their. Do they have an office? Are they registered through the President's Secretary? Stop registry to obtain the details and steps to be taken by petitioner upon the said NGO. Stop. As the lease is still subsisting, and, the prayer for interim, the matter of the hearing on the interim prayer will be taken up next date.
I'm just only fearful that they may pass some other adverse orders against me. So this will not hurt, because on the face of it, it is illegal.
Yes, prima facie on the submissions on the materials record. On the submissions and materials on record, a prima facie case is made out for issuance of interim orders at this stage. Accordingly, the interim or the impugn order shall remain stayed until further orders.
Lodge. Highly obliged.
Steps we've taken within
3 days.
2 days. Yes.
Obliged.
Let them come. We will grill them. See what they have to say.
Lodge.
Item number 2.
My lord, the petitioners before your lordships are aggrieved by the acquisition of their lands without payment of compensation.
You filed another case earlier, same thing, claiming to be forest dwellers. Is that same case?
Not exactly same, my lord.
Drawn early on, or is
No,
my
lord. My lord, these are another batch of petitioners, my lord. They are residents of certain villages there. Now the lands have been acquired, my lord, but no compensation has been paid. So they are aggrieved by this action.
It's been acquired.
My lord.
Possession taken.
No, physical possession has not been taken, my lord, but notifications under section 3
the names
has been published. The names of the beneficiaries have been published, but
the names have been published in section 11 notification.
Yes, my lord.
Where's the notification? Let's see.
My lord, the notification is annexure 11, translated copy, page 129, my lord.
Wait, it's that?
Page 129.
129.
Yes, my lord, our names do not figure in this notification, my lord. For the similarly situated people, they have been compensated, my lord. We have been excluded. That is why we are before your lordships, lord.
That means you are illegal occupiers. What do you base your rights on? You occupying these lands that have been acquired?
My lord, we have been the natural settlers in this land for a fairly long period of time, my lord. My lord, our settlement have been classified as villages, my lord. under the GHDC Village Constitution of Village Council Act 1958, my lord, the name of our village was published in the Assam Gazette. Subsequently, after coming out of the state of Meghalaya, my lord.
The courts want to know from this settlement, has the names of some people appeared in this Section 11 notification?
My lord,
For your village,
my lord, only khas lands have been. My lord, only khas lands have been served, and then
and this you say the names of these persons have been shown, private, so and so and so, in the schedule, correct?
Yes, my lord.
Now, do these people stay in the same village like you?
Yes, my lord.
Then,
They are in the same village, my lord.
have you filed objections against the Section 11 notification?
No, my lord. No objection was filed, my lord.
Then
No
you
objection was
have
filed.
for Section 15.
Yes, my lord. My lord, there is alternative remedy, of course, my lord.
No,
But however,
remedy now, because the law is very clear, provides a step-by-step procedure what you should do in such instances.
my lord, one representation.
Objections to acquisition or your wrong name, 64 later, 15 for the collector.
My lord, the petitioner number 1, my lord, right, Annexure 8, had filed a representation to the competent authority, that is the competent authority land acquisition, which is the Deputy Commissioner Revenue.
When?
My lord, this was filed sometimes in May 2025, my lord.
Where's that?
My lord, that is at Annexure 13.
Page?
Page 141. Page 141 to 144.
What happened to this?
My lord,
Also barred by anyway. What happened to this?
my lord, there's no outcome, my lord. Nothing has happened. They've left it in cold storage.
You take out that act Section 15. Yes, the Section 15. You read it out.
Sir?
Act 13.
Yes, sir.
I think Section 15. Yes. Yes. You come to this definition. You're any person interested in any land which has been notified as subsection 1 section 11 as being required, likely to be required by purpose. So you're interested, your names
Yes,
have
madam.
been shown. Then why have you filed an application of section 15?
My lord, though, of course, there is alternative remedy, my lord. But here is a case.
Of course, there is. I mean, it's statutory remedy.
My lord, there is a statutory remedy, but my lord,
also.
however, in this case, my lord, what has happened is that this is an act of arbitrariness, my lord. Some people have been given, some have not been given, my lord. So the
you're
alternative
interested.
remedy.
Suppose
my
a plot of
submission
land, you're staying a portion of it, and some, and the names have been notified. Mr. A, Mr. C is left out, Mr. D is given. Now, see, you file application section 15, and the collector will hold on to that. He'll hear your objections, he'll examine your locus, and then he'll make a report. And report, the report will go. If it's found that you are in possession, you're the owner, fine. If not, then go to 64 after the compensation has been deposited with the special reference court.
My lord, in this case, my lord, the acquiring authority itself is the competent authority, my lord, to take objections.
Exactly. That's the job of the collector.
Yes, my lord.
You file your, yes.
Lordship, the application is premature, my lord, because there are alternative remedies available before approaching the writ court.
Auto remedy is already exhausted. Within 60 days, I think is the time 15. Is there? Oh no, you file,
My lord, otherwise also, my lord, we have made a representation, my lord. They have not acted on it, my lord.
where the names of the people. It's not a question of general representation. You can't just say, this land belongs to me.
My lord, these people, my
If you
lord,
file
they are-
objection before the authority, if you want a proper adjudication, these people don't even know which land they're staying in.
no, my lord, these people, they know where
the
they are
extent
staying.
of their cultivation or occupation.
My lord, of course, they are aware of it, my lord. But
just stabbing the dark and expecting orders from the court, to put the deputy commissioner on a wild goose chase.
my lord, these
You
people
take
are,
instructions or you won't entertain it. These people, you understand that, maybe the people have been, but then it's not
these
the
people
correct
are,
procedure.
they are, my lord, they are illiterate.
Then you file application, the court direct you. You file a section 15.
My lord, section 15 again.
Have you mentioned why you have not taken recourse section 15 here in the petition?
No, my lord.
No whisper of that, my lord.
My lord, we have not mentioned that, my lord, but what we have mentioned is that we have filed representation and the representation have been kept in cold
What
storage. my lord.
representation? If the law provides a certain remedy, you avail of it.
My lord, of course.
From Garhil, this is happening. Just people are
My lord, what
trying
is
to
happening?
obstruct the progress of the road, or what do you call it?
My lord,
widening.
This project, my lord, it stretches across 3 districts, my lord. In all the other districts, my lord, everybody whose lands have
Exactly.
has
Why
been
make this
compensated,
prayer
but
for? Go and make this prayer for the deputy commissioner, for the collector. Why make this prayer here? Just trying to make you understand.
My lord, my lord.
That
I do understand that.
Disputed facts also.
My lord.
I can dismiss this writ at the threshold.
No,
You take instructions.
my lord.
We'll listen after 1 week. Yes. Yes, heard Mr. T.C. Gautam, Leonard Counsel with the petitioner, and Ms. N.G. Shilla, in terms of for the respondent. No notice at the moment. Petitioner, Leonard Counsel petitioner prays allowed to obtain instructions. List after 1 week. He explained to them.
Yes, ma'am.
Help them prepare the petitions. Make the holding, the holding is occupying. That is what he has. That's how you go about it.
My lord, the only problem is that, my lord, the entire Garo Hills, my lord, it is in a state of chaos and disarray, my lord.
Not really, Mr. Gautam. Many of them have patas which have been addressed by the collector, and those have
My
been
lord,
paid.
most of these are either Nokmas or little fortunate
You
people.
can't come, I'm forest dweller. You can't. Just stab in the dark. Yes.
Much obliged, lordship.
Obliged.
Please, my lords. My lords, I was offered appointment as Constable GD in CRPF at the stage of verification of my documents, my lords. In my mark sheet, 10th mark sheet, my lords, there was a discrepancy in my date of birth. The discrepancy is, my lords, it should be 28/4/2001. Instead, it appeared as 28/1/2001.
And for that, you've not been given a job.
No, so they asked me to go and correct it, Millets. So I went back to CBSE, Millets. I made the application. CBSE finally corrected it and gave it back to me, Millets, at page 67. So since 2024, Millets, I have submitted the original corrected version with the CRPF officials, Millets. Still today, nothing has been done. And I've been writing representations to them repeatedly. If I may just take your lordships to page 67, Millets. 57 and 67, these are the 2 pages. 56, if my lords, can you have a look at page 56 first? Well, let's kindly see date of birth. It's shown as 28/1/2001. Well, it's Himadri Deb, Neela Deb, just below Neela Deb, Millets, 28/1/2001. Now, my lords, there was a defect in this, so my lords, I was asked to correct it, and page 67, my lords, may kindly have a look at it. My lords, again below Neela Deb, my lords will kindly see it is 28/4/2001.
Yes.
That's the
But
limited
the
edition.
photograph doesn't look 24 years old also. He looks like a small boy.
This was, my lords, at this stage of class 10.
Oh, okay.
But the only difficulty, my lord, they'll have to approach Guwahati High Court. They'll have to approach Guwahati High Court, my lord.
Recruitment was in Guwahati.
My lord.
Yes.
Not a similar order has been passed by lordship just recently.
In that Mr. P.T. Sama's case,
PK Bora's case.
P.K. Bora's case.
Because
Does he have
also
advertisement?
Guwahati. On page 51, lordship.
Where's the advertisement for the recruitment?
My lords, the advertisement will, my lords, would find at page 18.
88.
18, 1/8.
And recruitment rally was held when? Or exam?
Happy Valley, Shillong, my lords.
Why you say it should be in Guwahati High Court, Mr. Dr. Modika?
Page 51, lordship kindly see, my lord. The appointment order has been issued from America, my lord.
CRP?
CRPF.
Oh, then yes.
The address of the petitioner, my lords, is shown as
It doesn't
Shillong.
matter because the other orders have been passed by this court. We can't put in by this bench only.
My learned friend has been kind enough to just supply me a copy. If my lords kindly have this matter tomorrow, I'll examine this.
Explain to your client. You've got a good case.
Item 7 for referral to mediation. Item 7.
We are praying if it can be sent for mediation tomorrow or today or tomorrow.
Last time you were not agreeable.
Also, there were some differences of opinion, but
It can be. There is no harm in trying, Your Lordship.
Daily list. Item number 1.
Armaji. I think they know. Who's there for the election matter?
Yes, Your Honor.
At 2 o'clock, we'll take up the evidence.
Yes, Your Lordship.
Item number 2.
May it please, Lordship. Lordship, in this matter, I'm praying for some more time. I'm seeking accommodation to file my affidavit. Lordship, if Your Lordship, on the last occasion, my Lord, the miscase was disposed. Miscase for vacating the ex parte order. So, Your Lordship, in this matter, we have taken instruction. We're just awaiting instruction, my Lord.
Was this post for vacating?
The ex parte order, Your Lord. There was an ex parte order passed.
For hearing ex parte?
Yes, ma'am.
It's been vacated?
Yes, Your Lordship.
Why you want more time to file affidavit?
Lordship, we are just seeking instruction and we are awaiting instruction in this matter.
Okay, as prayed further 2 weeks, 7 out to 1, 6 and 7 to file affidavit. You file yours.
Yes, Your Lordship.
Item number 3.
Hello, Bhaji.
May it please Your Lordship. Lordship, we are appearing on behalf of the respondents. We need another week's time, Your Lordship, to file our affidavit.
What's the contempt award?
the contempt award is a non-passing of the order by the officers, and the marriage committee
The
tenure
matter
is
has
going to
been-
expire very soon.
Why 2 weeks?
Just a week, Your Lordship.
You asked him to appear personally and explain.
Yes.
What is the...
No, Your Lordship, actually they have taken steps. We have put up the matter to the government for further approval, Your Lordship.
That is the problem, Lordship. The court has directed a specific officers, particular officer, to dispose of it in accordance with the law, and some politicians are involved in these matters. That's what we
Why
file a
put government?
contempt.
That is what we have been told. The instructions are that, Your Lordship.
That's
The
what I
matter has already. So we'll do one thing, Your Lordship. We'll take 3 days time.
His hand is tied, these officers. He cannot do anything.
3
because,
days. Another 3 days time will be allowed, Your Lordship.
Stop. A prayer has been made today for further time to file the affidavit. Stop. He has further submitted by learned EAG that the order stage of compliance, but the same has been placed for the government
The competent authority.
for approval.
Yes, Your Lordship.
Where they have directed the respondent number so and so to do this.
In fact, both the parties were heard also by the Director of School Education and Literacy, Your Lordship. They were summoned, they were heard, and then the matter has been placed before the competent authority.
By order date 5/3/2025, this court had specifically directed respondent number 2, the Director of School Education Literacy, to take a decision. But it's expected that an affidavit should be on board on the next date. Yes.
Oblige, Your Lordship.
On the next date, with regard to the compliance of the order stated violated.
Item number 4.
The petition is to file the rejoinder, Your
May I
Lordship.
please, Your Lordship? During the course of the day, we will file the rejoinder, Lordship.
Very good. Absence also. Submit the rejoinder to court that he acknowledges the matter for hearing after
2 weeks, Lordship. Hand over.
5.
May I please, Your Lordship? Here we file the affidavit, rejoinder affidavit, Lordship.
Yes.
We already filed, Lordship.
You filed agenda.
Yes, Lordship.
So please for hearing.
Yes.
Yeah, the parties submit the appeals are complete. This is a matter for hearing.
Yes, Lordship.
Item number 6.
Lordship, here we will file our affidavit in course of the day, Your Lordship. It's ready. We just have to file it.
Another EAG submits the affidavit in course of the day. It's up to 2 weeks for rejoinder of any.
Your Lordship. Obliged, Lordship.
7.
Your Lordship, affidavit and opposition completed.
It's been filed.
It is filed.
Yeah, please, Lordship. We will file the rejoinder, Lordship.
Already filed rejoinder also?
Not yet, Lordship.
You won't file?
We will file, Lordship.
Yes, so please that allowed to file rejoinder. Please for 2 weeks time to file rejoinder.
And your blessed Lordship.
8.
My lord, we have just received the copy of the affidavit, my lord. Kindly allow us 2 weeks time to file the rejoinder to this, my lord. This morning only we have served.
Mr. P. Euban submits that as he's just been supplied with the affidavit of the respondents, he prays out 2 weeks time to file rejoinder. Praise allowed. Yes.
Obliged.
9.
Yes, Mr. Patak.
Now, this is for affidavit, my lord. I'm praying for some more time. Sir, I'll place by
for hearings.
I'll place affidavit record.
Okay, though Mr. B. Patak submits that the matter is covered by a judgment of this court, if it does not warrant any affidavit, Dr. N. Mozikali I praise he will have further time
3 weeks time
to put an affidavit on record. For only 3 weeks time granted. Stop expecting the next day the affidavit to be on board. Yes.
Item number 10.
My lord, I just received this morning an affidavit filed by the petitioners.
By the
petitioners. Rejoinder, my lord.
You listed for hearing?
Listed.
My lord, here, my lord, the pendency of the matter here, what happened, my lord, this is pertaining to a VC, my lord, election to VC. Now, another writ petition has been filed whereby this honorable court has stayed the conduct of the elections, my lord, and directed for re-verification of the job card holders, my lord. And in the interim, my lord, what the government has done.
First of all, hearing because the counsel for this matter is not available, my lord. Mr. N. Sinkon.
This some urgency.
But the urgency in the sense, my lord, the committee has been
for hearing after 1 week. You mentioned
after 1 week.
Yes, files submit that please complete. Stop and the matter be posted for hearing. However, as it is submitted, there's some urgency. It's the same after 1 week.
Right. But the other matters are coming on 5th of August. It's going to be listed together on 5th.
Only on 5th of August. Are you correct? We're just sitting in submission.
Yes, ma'am. We've checked.
Item 11.
Your Lordship, we brief 2 weeks time to file an affidavit, Your Lordship. This is regarding regularization from the date of initial appointment as ad hoc employees.
But in fact, not item
15,
11, 12, 13 and the hearing matter at 15. The issue involved
Are the
11,
same.
12, 13 and 15, my lord. 15 is in the hearing list, my lord, ready for hearing. The issue is the same, my lord, regarding, my lord, they were seeking to recover the, my lord, ACPS that was granted to us. And we have been regularized only subsequently in 2023, my lord. Now recently there's some development, my lord. So, my lord, let that development be brought on record.
that is what I pray, Your Lordship. As far as item 15 is concerned, Your Lordship, and we need specific instructions. What are they?
Because then the relief will have to be molded, my lord.
ACP have been relaxed according to this office memorandum which I have received, but we'll bring it on record by way of an affidavit.
Ms. T. We learned it AAG. So pray for about further 2 weeks time to file affidavit stuff. She also submits that the recent developments will also be placed on record.
If an affidavit.
All these matters, my lord, 11, 12, 13 and 15.
13 and 15, Your Lordship.
Deeply obliged.
Obliged, Your Lordship.
Hearing. Supplementary list, item number 4.
Where's the petitioner?
It's coming, Your Lordship.
Where a petitioner? For a petitioner?
My senior will come, Your Lordship.
Who?
SD will come, Your Lordship.
In fact, yesterday they prayed for disposing in terms of the earlier order, my lord. Your Lordship kindly.
What order?
Lord, kindly sees affidavit of respondent number 8, 9 and 10, my lord. When is the order?
Yeah.
Page 55, my lord, is the order part.
Yes.
Para 17, madam. Well, a similar challenge to land acquisition, my lord, and this was the outer part at para 17, madam. That they are at liberty to approach under 64 or whatever, madam. However, dismissing the writ petition, madam. Para 17.
Para 17.
Yes, madam. There are no harm in that.
To approach under 64 of the Act.
Let me see para 17.
Lordship, I have
Page 76, madam.
judgment.
It's there.
Yes. At the outset, Mr. S. Deb, General Counsel for the petitioner, submits that the writ petitioners
It's the same judgment, Lordship.
writ petitioners may be allowed the liberty to seek remedy under Section 64 of the Act 2013 with regard to the grievances as to the as to the issue of compensation.
Issue of compensation, adequate compensation.
Petitioners. Stop. According, the same is also acceded to by Dr. N. Mozika, Learned Counsel for Respondents. 8 and 10. 8, 9, and 10, as also the other state respondents. In view of the submissions, the petitions close with liberty given to the petitioners to file appropriate application of Section 64 of Act 2013 before the competent authority, who shall deal the same in accordance with law.
Obliged.
Item number 5.
May it please your lordship.
The hearings are last year.
Yes.
Release ka? The main release. मैं भाई का तो करता हूँ. Okay.
May it please your lordships. My lord, this is the case where here the read petitioner, my lord, he is working as a lecturer in the Shillong Polytechnic.
Working as a?
Working as a lecturer, your lordship.
There's still lecturer post exists nowadays.
No, my lord, they should have changed the designation. They have not changed. But this is Polytechnic, of course, my lord. AICT, I'll come to that, because AICT also, my lord, they have not gone into, they have not changed the designation.
This is a lecturer and reader and everything.
Not reader, lecturer, senior lecturer, selection grade lecturer, that much. It's unlike, my lord, UGC. I'll take my lord to that. This designation remains. So, my lord, he was, my lord, initially appointed on ad hoc basis 2004. Subsequently, on the recommendation, my lord, he was regularized, my lord, in 2006 with effect from 7/6/2004, my lord. These I have annexed at Annexure 1, your lordships.
He was appointed initially in 2004.
2004. My lord, that was on, my lord, ad hoc basis. Subsequently, on the recommendation of MPSC, my lord, he was regularized with effect from, my lord, 2004. Now, my lord, here, my lord, lordship will, my lord, what happens here, my lords, there are two kind of scales are available. One, my lords, as per the, my lord, norms prescribed by the state government, norms, my lord, they have their own pay scale, state pay scale. So initially his appointment was on the basis of the state pay scale, your lordships. Now, my lord, lordship is aware, my lord, so far AICT is concerned, my lord, they are the, my lord, competent authority, my lord. This is constituted under a statute, my lord, which looks after, my lord, lays down the norms and other thing, make recommendation for technical educations. And, my lord, so far, my lord, pay of the teachers are concerned, your lordships. They, my lord, following the Central Pay Commission, my lord, they prescribe the pay scales with different condition of service and opportunities from time to time. And, my lord, here also like UGC, my lord, they provide the state government may extend the AICT pay scale also to their teachers in the polytechnic, provided they have the AICT norms, not otherwise. This is the thing. Now, here what happened, my lord, 2011, your lordships, state government has extended this AICT pay scale to the teachers of polytechnic. 2000 and my lord.
2004, you're enjoying that state pay scale.
State pay scale, my lord. Now, my lord, if I can take my lords to Annexure 2, page 29, my lord. That is in 2009, state government has extended, subject to certain condition.
That is page 29.
Page 29, Annexure 2. Well, if I can read it.
English.
Is English. 27th October 2009 notification. The Governor of Meghalaya is pleased to allow the implementation and extension of All India Council for Technical Education pay scale with central DA only and no other annoyance to 39 existing faculty members of Shillong Polytechnic, Shillong, subject to the following condition. The date of effect may be from 1/1/96 but without any arrear benefit. However, the faculty members will get the benefit of notional fixation regarding pay structure. Principal Polytechnic, it was revised to follow the pattern as adopted for principal government colleges UGC pay scale such and such. The age of superannuation would be as applicable to the state government employees, not as per AICT recommendation. The post under plan, which has been in existence for more than 5 years. Now, my lord, admittedly, ultimately, this pay scale was given to me, your lordships, with effect from 2011. Actually, it was given to me from 2011. Now, my lord, AICT pay scale, my lord, at that relevant point of time, my lord, 2011, my lord, following the 6th CPC, my lord, AICT formulated its rules under that, providing what would be the pay scales and other things, and that was notified in 2010. So in 2011, when I was granted this pay scale, my lord, the 2010 rules of the AICT was holding the field. So I was granted this pay scale, and as per the 2010 regulation, my lord, there are a lot of schools under CAS, Career Advancement Scheme, my lord, for upward movements, and my lord, also for promotion from lecturer to senior scale lecturer. Now in 2013, your lordships, they have considered my case for promotion under CAS. 2013, I will take my lot to that, and I was recommended for promotion to the senior grade. 2013, my lord. I will take my lot to that recommendation.
Page 86.
Page 86, my lord. Page 86, your lordships. 14 June 2013. On the recommendation of the screening committee for Career Advancement Scheme, the lecturer of Shillong Polytechnic, Shillong, held on 2nd May 2013, the Governor of Meghalaya pleased to place the following lecturer in the senior grade selection grade ICT scale as indicated against their name with effect from the date as indicated below. Now I appear at serial number 10, your lordships. 2/6/2004 date of appointment. Now with effect from 4/6/2012, my lord, I have been placed in the senior grade, lecturer senior grade.
So how many categories there? Senior grade, junior
then
grade?
selection grade. Senior grade after
lecturer, then selection grade.
Selection grade. Senior grade, then selection grade.
Oh, sorry. Senior grade and selection grade.
Selection grade. Now, my lord, here your lordship, my lord, though I was
associate professor, assistant professor, associate professor.
It's not. I'll just take my lord through the rules, recent rules of AICT. They have only lecturer, senior scales, and then head of the department. It's unlike, my lord, UGC. Now what happened, my lord, though this recommendation was made, my lord, this was never given effect. I was never given that pay scale. But I was always expecting that this will be done. It was never done.
The scale is never given to you?
Never given to me. This, in spite of this recommendation, I was never given this pay scale. Now what happened in, my lord, 2024, your lordships, which I have challenged, my lord, that is at page, your lordship.
87.
My lord, page 87.
The next lecture only.
Next lecture, my lord. Now, my lord, this is from Secretary Senior Account Officer. In suppression of this department letter dated 14 June 2013, in pursuant to the resolution number such and minute of the screening committee held on such and, I am directed to say that such and such lecturer English, Shillong Polytechnic, Shillong, was considered for career advancement scheme by invention letter dated 7, which possesses second class both degree and master. However, as per AICT Faculty Norms Regulation 1999 and AICT Faculty Norms Regulation 2010, clarified at point 10 of the AICT Notification 2016, first class or equivalent at the bachelor's master level in appropriate branch unities is required for consideration for CAS. In view of the above, Lingua is hereby allowed to exercise his option in writing within a period of 30 days from the date of issue of his this letter on either of the following: to continue in the existing AICT scale with no further increment or CAS promotion, or to revert back to the state scale pay with pay protection, the last pay drawn AICT such and such, such and such. So these were the option given to me. Either you continue with the AICT with no further increment, nothing. The reason, my lord, you do not have the first class.
That's the requirement of the
that is the only issue here, my lord.
Then,
AICT issue. Now, admittedly, my lord, I am a candidate, my lord, and I have, my lord, in the master degree secured 55.5% marks. Below 60%. Now, first class, my lord, I'll take my lord to the rules. They said either it is declared as first class or otherwise it will be 60%. So here, my lord, in Nehu and everywhere, 60% is the first class. So, my lord, I am below 60%. Now, my lord, subsequently in the UGC, my lord, has clarified this position. They have clarified this position, my lord, by notifying a rules, not by just my mere statement, by notifying a rules under the AICT Act, saying that so far, my lord, SC, ST candidates are concerned. They are entitled to, my lord, concession as per the state government's norms in the matter of appointment. In the matter of appointment. So, my lord, taking this into consideration, my lord, I was always eligible, even now I am eligible, my lord. 55.5, my lord.
Appointment, not promotion.
Here, my lord, the issue will come. This issue will come, my lord.
Then?
What is this promotion? Is the promotion? This is exactly what the state government is saying. My humble submission, this is only a mode of appointment. Now, my lord, they have withdrawn with pay protections. Now, lordships, if I can take my lords to the UGC, my lord, those amended rules, amendments, that is at, my lord, page, it starts from page, my lord, 67, Annexure 5. Well, clarification, my lord, the All India Council for Technication dated 4 January. Clarification of certain issues, anomalies pertaining to qualification, pay scale, service condition, career advancement, etc. for teachers and other academic staff or technical institution, etc., my lord. Now, if I can take, my lord, short title next, my lord, 2. AICT has received several representations seeking clarification in certain issue arising out of implementation
Where
of
are you reading from?
my lord, at page 67, my lord. Roman 1 is, my lord, the short title and commencement.
Okay.
And number 2 is the general, my lord. That's my lord. Given
general.
General, my lord. What is the intention of this clarification? AICT received several representations seeking clarification on certain issues arising out of implementation of AICT regulation 5th March 2010 on revised pay scales, service condition and qualification of teachers and other academic staff and technical, and in 2010, and career advancement scheme of teachers and other academic staff in technical institution 2012. Some of the issues raised in the previous notification have also been included. Now, my lord, these are the clarification, my lord. The relevant clarification next page, my lord, at serial number 4.
Yes.
Serial number 4, my lord, if you can read. Consideration on undermentioned issues for the purpose of appointment of various teachers in the degree and diploma technical institution. A. Relaxation on minimum passing qualification criteria for differently able physical. Number B, that is important. Relaxation of minimum qualified marks 5% to ST candidates. Now, what is the answer, my lord, in the next column? Rules relating to reservation for respective category, including relaxation in minimum qualification criteria of the concerned state, UT, central government as applicable from time to time would apply. So, my lord, they are saying, my lord, that 5% relaxation is available to the reserve category. So, my humble submission, my lord, and they were conscious about it. That's how they have given me in 2013. 2011. I have been granted this AICT pay scale, and further promotion was recommended in 2013.
Yes.
Now, my lord, there I think only I have gone there the affidavit, my lord, nothing except this issue, that this relaxation only in the matter of appointment. So these should not be.
Where have they given that?
No, they have said in their affidavit. So these should not.
But then, if the question is, what will be the definition, or what will be minimum qualifying mark? Will it be applicable across, from appointment to promotion?
Yes, my lord. So far, my lord, the reserve category is concerned, my lord, it will be applicable. Because there is no restriction. Otherwise, lordship.
No. What is court saying? The other point of time when he considered for CAS,
lordship,
was the requirement of 60% given in that your CAS scheme?
No, see, my lord, as per the norms of AICT, it is always 60%.
Okay.
60%, then, my lord.
Not irrespective of appointment, promotion, everything.
Everything, my lord. There is no different benchmark for promotion again.
So, your case is that since you were placed in the IICTE pay scale, 2011, that means it's a given that, that was also looked into, and so 55 will prevail.
Yes. Once, my lord, what I want to convey, once I entered the service, my lord, with AICT norms. Now, AICT norm, my lord, for a reserve category, my lord, it can be 55%. Even if it is 55%, adding another 5%, I qualify. So once I enter into service, my lord, there is no different benchmark. Now here, my lord, if we take, if we accept the contention of the state government, this will create huge confusion. They think this will apply only in the matter of appointment. Now, lordship, think about the situation. A person having 55% marks, my lord, he applies in an open selection. Now he was considered giving additional 5%, 60. He entered the service. Then they will say when his CAS comes, he is otherwise eligible as per AICT norms. When his promotion under CAS comes, sorry, promotion we cannot give. That will lead to a very absurd classification, my lord.
Okay.
And there is, my lord, nothing that for CAS, again, they have said that there is a different benchmark, nothing. Once you are, my lord, AICT, you have the AICT norms, my lord, and you are performing all right, subject to screening, there is no other requirement and stipulated length of service, you are eligible for promotion. Now, my lord, even if I can take, my lord, the recent rules, 2019, I have annexed, my lord. 2019, my lord, following the 7th CPC, my lord, AICT has issued the fresh rule regarding the service condition of teachers. My lord, that I have annexed at Annexure 3, page 30.
Yes.
Page 30. My lord, 31, your lordship. Even they have said mode of appointment in the table. What are the designation and what are the pay scale and mode of appointment?
Where are you reading?
Page 31, my lord. This is the part of the, my lord, the rules, and that is, my lord, the AICT rules of 2019. This is the latest rules, my lord, following the 7 CPC. Lordship. My lord, lordship will look into the, yes.
Yes.
31. Lordship will look into the table they have said, cadre structure and mode of appointment. The rule itself say. Now, my lord, first column is a designation of teacher, lecturer, my lord, direct recruit, lecturer by promotion. Now, these column, my lord, the last column, lordship will see on the top, mode of appointment. Now, mode of appointment either could be direct recruitment or it could be by way of promotion or direct recruitment. So rule is very clear and categorical, my lord. So there is no scope of confusion. And even otherwise, my lord, without this rule also, my lord, promotion is a mode of appointment. Had their intention, my lord, that it was restricted only to direct recruitment, my lord, they would have categorically mentioned there. They would not have issued the, my lord, generally the terms appointment.
Yes.
My lord, even otherwise, as I said, my lord, it will lead to very, very absurd situation, my lord, if, my lord, the contention raised by the state in their affidavit is accepted. So, my lord, this is the only ground, my lord, nothing else, only on the...
Only the Annexure 7, page 87.
Yes.
That's
yes,
it.
sure.
That's
Now, my lord,
13-2.
now, my lord, what are the benefits I am losing, my lord? I will just place your lordships. One, I am in AICT pay scale. Now they have shifted me to the state pay scale with protection. So far, financially, as of now, my lord, I am not losing. I have set out, my lord, what is the financial. I am not losing anything. The problem will start, my lord, when, your lordships, when the next pay revision comes of the AICT, it will be much more impressive, number one. Number two, they give a lot of scopes to the teachers, much better than the state government. And it's not that I am not asking for it, my lord. I am eligible. Why I should be deprived? If I am eligible, they should not have deprived. They have granted me 2011 and 24, my lord, after 12 years, my lord, 13 years, they have taken these decisions. So if I can take, my lord, to page, I have just made a table, my lord, just to show, my lord, what was my pay scale in 24 when I was shifted under AICT, when I was shifted to the state pay scale. I have just made a table and annexure 8, page 88. Page 88.
18.
88. Lordship.
This is your table.
No, I have, my lord.
Made by the petitioner.
Made by the petitioner. Now, my lord, in the month of April, my lord, the last pay drawn under AICT.
Yes.
Now, my lord, will see 98,200. This is a basic, my lord. Then I was under AICT only entitled for DA this, not entitled to HRA, HCA, MA. Then the gross come to this GPF, my lord, after deduction, take home, my lord, this 1,33,372. This was my pay scale, my lord, when I was shifted to the state. This is the last pay under. Now, my lord, under protection, my lord, lordship will come to the last May, the state scale with protection. Now, what I am getting, 98,400 plus, my lord, DA. Now, state government, of course, my lord, they give HRA, HCA and other thing. Together it comes 1,40,212. Slightly better.
Gross is 1,50,000.
Yes.
So you deduct your GPF of 10,000. So you take home 1,40,000.
Yes.
So you take more.
Yes, my lord. So that is
the AICT current scale.
AICT current scale is this, my lord.
Yes, less. And so now
less, my lord, I'm coming.
But you're expecting a higher
opportunities. This is the case of opportunities. This is the case of opportunity.
You want a lower scale? Let's just look out.
These opportunities. My lord, it's the question of opportunities. And my lord, when the second pay revision comes, it will be much more better, my lord, than the state government. And the opportunities, my lord, lots. Other thing is this: I have acquired a PhD degree while in service in 2020. Now, under the, my lord, UGC norms, I mean UGC condition of service, I am entitled to 3 additional increments. Those things I will not get in the state.
Okay, that's your case.
So that's the entire case is on this, my lord. So they cannot make a distinction. And the other thing, my lord, just for your lordship, my lord, just to assist, my lord. Other state, I have annexed the notification. All other state, my lord, following this UGC, my lord, regulation, they are granting, my lord, that 5% concession. I have annexed the notification of state of Andhra Pradesh, state of Assam, both. So my humble submission, my lord, there are, my lord, three things I am asking you. Put me back to my AICT pay scale, number one. Number two, my lord, my CAS, career advancement scheme. Now they are saying, my lord, career advancement scheme, my lord, there were certain irregularities in 2013. Other than that, my lord, first class and all, my lord, they are saying that the certain irregularities. Assuming that there are certain irregularities, their lordship is aware, under CAS, my lord, it cannot be deferred. Then they are under obligation to consider it now and grant me with a retrospective effect. And thirdly, my lord, my additional, my lord, incentives, 3 additional incentives for PhD.
Here's your prayer. You're asking for all that?
Yes, my lord, I have asked. Page 23, my lord.
Yeah, okay. Additional increments for yes.
And my lord, the other thing, my lord, here my lord, even the, my lord, Office of the Accountant General, my lord, they have seen in an affidavit with the ASC 2011. He said, you have granted these people this AITCT pay scale. Now withdrawal of these, my lord, creating a lot of confusion. That is also there by an affidavit by the Accountant General. The Office of the, that withdrawal of this is creating a lot of confusions and irregularities. So my humble submission, this is the case, my lord, only thing whether I am entitled. Admittedly, my lord, my mark is 55.5. Requirement is first class. The AICT, my lord, amendment is very clear and categorical. Appointment. And they say mode of appointment, promotion is also a mode of appointment. So my humble submission, my lord, it call for interference.
Yes. Amit, this is your lordship. Lordship, first, your lordship, my first contention is that, your lordship, the petitioner is barred by the principle of estoppel and waiver. Why, your lordship, I make that submission? Lordship, kindly have the affidavit filed by the state. If lordship kindly come to page 21.
1 second.
Lordship.
1 second. Yes. One, 5 to 5 and 8.
Lordship, page 21, your lordship, of our affidavit, your lordship.
21. Page 21.
Lordship. Lordship, this is the representation, your lordship, written by the
yes.
By the lordship at page 21, your lordship.
Yeah.
This is the representation, your lordship, written by the lecturer of of the Shillong Polytechnic. Lordship, kindly see at paragraph 2, your lordship. What did they say?
Yes.
That after the government notification for the implementation of the ICTE pay scale for the lecturer of Shillong Polytechnic by notification, so the government is still following the same procedure prior to in placing the lecture in various scale by notification, which is not in accordance with the latest your lordship. So your lordship, their contention is that the order of 14/6/2013 is not in order, your lordship. Kindly have come again to the writ petition at page 86.
Make this court understand that after the government notification for the implementation of the EICP scale for lectures in Shillong, made by the where's the 27/10/19, that's annexure 2 of the petition.
Lordship.
Okay.
Kindly have 27.
Okay, 1 second. Just
Lordship.
try to understand. Annexure 2. Annexure 2 Yes, that's notification by
Lordship, that is
by
annexed
the
to
governor. Correct.
Lordship, yes.
Yeah, please to allow the completion of extension on India, AICTs, PSKLs with settled DA, no other allowances. Okay, fine. Now you say that in this representation,
so according
to it's still following the same procedure prior.
Still following the same procedure prior to 27/10/2009.
Okay, what impact will it have?
In placing the lecture in various create by notification number so and so, which is not in accordance with the latest. So, Your Lordship, according to the writ petitioner, Your Lordship, he is also a signatory to this, Your Lordship. He is at Lordship, kindly have page 22 at serial number 4. Lordship, yes. So, according to the writ petitioner, the order of the governor notification dated 14/6/2013, Your Lordship, is not in order, Your Lordship. It is in his own admission, Your Lordship.
Not in order, no, not 27/10/2009, and so is not in accordance with the EICT.
Lordship, can you see by notification dated 14/6/2013, which is not in order. That means the annexure 6 at page 86, Your Lordship, that is the notification dated 14/6/2013, according to the writ petitioner, is not in order, Your Lordship.
Granting them that
Lordship, is not in order, Your
granting them a senior grade.
Lordship, it's not in order, Your Lordship.
But according to you, it is in order.
Lordship.
According to you, according to the state
Lordship, that is why when we have this, Your Lordship, then we rectify the mistake. We rectify.
Then?
Can you see, Your Lordship? Dated 14/6/2013, which is not in accordance with the latest notification.
Okay, latest notification, 2010. Okay, then?
Now can he raise, Your Lordship? If he himself say that it's not in order, can he take the protection of the order dated 14/6/2013?
My contention, Your Lordship, the withdrawal of this government ultimately passed an order which I have challenged. What is the ground for withdrawal of that promotion? Only on the ground, my lord, that I don't have first class. No other things, Your Lordship.
No, but even then, this has some impact.
No, that I have.
You represented saying that the 2013
I finally rejoined.
Implemented. So, if not if according to you, if not implemented, then how can you say that now you're seeking?
Can you see, Your Lordship?
Taking shelter of 2013.
I have filed a rejoinder.
Can you see, Your Lordship? The writ petitioner is an educated person, Your Lordship.
I'll just rely on my rejoinder.
The writ petitioner is an educated person.
You have a point.
And he suppressed this, Your Lordship. He suppressed this, Your Lordship. Nowhere he has stated this representative in the writ petition.
He forgot about it, maybe, conveniently.
So, Lordship, he is guilty, Your Lordship, of suppression of material facts, Your Lordship. Lordship, 226 jurisdiction is an equitable jurisdiction, Your Lordship. A person should come with clean hands, Your Lordship. He should not suppress things. He should come clean hand. Please the thing, please the material.
Okay, leaving this letter aside, revelation aside. Now, what is the stand of the respondents?
Lordship,
13 stands.
Lordship, I'll come.
Does the authority
if Lordship
that warranted the withdrawal in by the
Lordship, yes. Kindly come to the affidavit, Your Lordship. We have explained it.
2024.
Lordship, yes. We have explained it, Your Lordship, in paragraph 5, Your Lordship, of the affidavit. Paragraph 5 and 6, Your Lordship. Kindly have our affidavit, Your Lordship. The admitted fact, Your Lordship, is that the petitioner was possessing, Your Lordship, a second class in bachelor and also second class in master degree level, Your Lordship.
Yes.
And if
let's forget about that.
The Lordship, yes.
Then?
Because, Your Lordship, this relaxation, Your Lordship, relaxation, Your Lordship, this is meant only for the purpose of appointment. Lordship, kindly have that. Lordship, kindly come to page 25. that is All India Council for Technical Education notification, that is 4/1/2016. If Lordship kindly have at clause 4 at page 26.
Yes.
Lordship kindly have clause 4. Consideration on the under mentioned issues for the purpose of appointment. Lordship will speak of not for promotion, Your Lordship. On various teaching posts in degree and diploma technical institution, relaxation on minimum passing qualification for Lordship will not be, Lordship kindly see, relaxation in minimum qualifying marks by 5% for scheduled caste, scheduled tribe. So this notification, Your Lordship, of speak of appointment, not for promotion, Your Lordship, under the career advancement scheme, Your Lordship. It's very clear. The rule is very clear, Your Lordship.
Well, that can be stretched. We can read down this appointment as promotion, because if there is a possibility that it could win also, we cannot hold it steadfast.
Lordship, because Lordship,
if the qualifying marks for entry into service,
this is
as per
Lordship, in my humble and respectful submission, this is for the purpose of appointment, not for the purpose of promotion.
Then where will he go?
Lordship, that is why
that he doesn't have that. That means he'll be stuck there. There'll be no.
No, Your Lordship. Kindly see the impugned order which is challenged, Your Lordship. What does it say, Your Lordship? Lordship, kindly come to page.
Yes, we have an page 7.
Lordship, kindly have at page 87. It says like this, Your Lordship. In suppression to this department letter number so and so, dated 14/6/2013, which the petitioner say is not in order, and in pursuant to resolution number 4 of the minutes of the screening committee held on 10 October 2023, I am directed to say that Shri, that means the petitioner, Lordship, was considered for career advance scheme by letter mentioned above under so and so, even though he possessed second class at both degree and master level. However, as per the ICTE faculty norm 99 and so and so 2010, clarify appointment of so and so first class or equivalent at bachelor or master level in appropriate band humanity is required for consent for caste. In view of the above, Shri R. Lingwa is hereby allowed to exercise his option in writing within a period of 30 days from the date of issue of this letter on either to continue in the existing scale with no further increment or caste or promotion, or to revert back to state scale pay with pay protection. If with pay protection, according to the Lordship, is getting more.
Next page.
Next page. Lordship, kindly have at page 88. Lordship,
as I've seen.
Lordship, kindly see.
He is not more looking in the horizon, not in that.
Lordship, his entitlement is not. He's not entitled, Your Lordship. He himself said that the order 14/6.
So the only thing is that goes against him is that he, on a representation where he has signed, which does not deny, I think.
Lordship, yes.
No, I have filed a rejoinder.
Have you denied
I have
representation?
I'll just read it.
Then the thing is that now, whether you have not accepted 2013 notification, now can you take recourse to take shelter from it? That this 2013 has given me this.
CAS, my lord, assuming there is a irregularity. No, CAS is a time-bound promotion, my lord. So even assuming that they
don't go there, but it's a fact. Why you're not stated in the writ petition that?
No, Lordship, he has suppressed.
I filed a rejoinder.
No, I mean in the writ petition you have not said.
Suppressed, Lordship.
No, I have not said, my lord.
Why?
But in the writ petition I have said, my lord, what happened? They have still acted on it. The same others, they have acted on it. And the grounds for, my lord, cancellation, what is the ground for cancellation? Only this first class, not the representations. The grounds communicated that you do not have a first class, so we are withdrawing it. You are not eligible. This is the only ground they have said. And assuming, my lord, there is any irregularity, this is a time-bound scheme, my lord, governed by the statutes. My lord, even now they are under obligation, my lord, to consider my case, my lord, and give it with a retrospective effect. So this is CAS, my lord. This is not like other promotions. So once I complete the terms, I am suitable, I has to be promoted. And then comes, my lord, the incentives. What you will say about the incentives? And what, my lord, this is something very, 55% somebody qualifies, enter the service, Then he said it will not apply to promotion. Now what will happen? He will stuck there. That means so far promotion is concerned, a candidate, my lord, reserve category with AICT norms, with relaxation. If he enters the service, he will not get promotion. But this is a very, very absurd classification, my lord. This cannot be. Promotion, and I have referred to the rules, my lord. Rules of the 2019 rules say promotion is also a mode of appointment. So my humble submission, my lords, that cannot be a ground, my lord, refusing the reliefs. Because the ground they have said, only ground, my lord, that 55% marks.
So you overlook your
No, I'll refer to my.
You overlook the discrediting of the 2013 notification by you. That means you want to ask the court to do that.
If I can take my lot to my rejoinder affidavit.
Rejoinder. No. Oh, can I?
Yes.
Lordship. My lord, 6. Lordship, one of the relevant paragraphs is at page 6. My lord, I'll just read it. A small paragraph. Then the statement in the affidavit in opposition, deponent states it is not correct that none of the faculty whose placement has been made by such and such receive the benefits in view of the objection of the account generals of Meghalaya. It may be stated that all the incumbents in numbering 5 who were placed in the selection grade as per the notification have been granted the financial. They have acted on this thing, my lord. They have not scrapped it. Had they scrapped the entire thing on my representation, it would have been otherwise. As per the notification have been done. In any case, as per the AICT regulation, the case of faculty member is to be considered for placement under CES scheme on his completing the requisite.
Why not in your affidavit, in your petition? Why there is no plea that we have filed a petition, but it's acted upon it, and so we are.
Could have been, my lord, one thing. Even if I have filed a representative 2013.
Doesn't matter, but it should have come there.
No.
That even if representation had been made to discredit 2013, but the response acted upon it, and so we still agree with the situation. That's why we've come with this petition.
My humble submission, my lord, that should not fail.
I mean, your client was acting smart. He did not reveal it to you. That's what I know that.
I have explained. I have explained it.
You explained rejoinder after it has come out from there.
Explain it. Now the
question is too smart. Also, sometimes it boomerangs. It'll explode in your face. You know,
Client is an educated.
I think only this ground, your lordship, will not fail my petitions. Because
on a ground suppression is more than enough ground to
lordship, I need not
my lordship. Will this, my lord, even if lordship assume it is a suppression, my humble submission is not, because it will not.
Of course,
will it have what bearing it will have? It's not that they have scrapped. It's not that
it has a bearing. You're not fit to be promoted in a grade also.
My lord,
that's a bearing. If you can't even come clean for the court, what will happen to your students?
No, lordship will appreciate one thing, my lords. Here, the government has taken it. Government has said they have scrapped these. So far, I am concerned, only on the ground of 55% 5.
They have not said that.
They have said
they have just come with your representation saying that you are qualified. Fine. That is
what is the communication of the government which I have challenged? That communication
we're
says.
Not concerned about that. We're concerned about why have you made representation without and you suppress that.
No, my lord, I will not say. I have sufficiently explained it, my lord, in my rejoinder. That cannot have
been exposed.
No, my lord.
Conduct of the
I have said, my lord, it has not been done.
Unfortunate.
Now what happened 2013, my lord? What happened 2013? 2013, I have said, my lord, this is not
authority that shows that if you suppress also, but you entitled by law.
No, my lord. Does it have a bearing, my lord? What bearing? What bearing it will have on the AICT pay scale?
Give her a decision.
No, my lord.
That even though the peer has not revealed before the court, but since by law he'll be entitled to relief, should be given.
My lord, it is not that on my representation it has been scrapped. It has never scrapped.
No, it's not. A scrap. Your representation says that we discredit that 2013, by which we made senior grade, and then now you're seeking, relief to,
This is one of my relief
for setting aside 1,000 for superseding 2013. So exactly that's you are at cross purposes.
No, my lords. My here I am asking for 3 relief. Put me back in AICT pay scale. Number 1. Number my incentives, my lord, and thirdly your lordships. The CS. Well, my humble submission, my lord, these should not be fatal, your lordships, because they have never scrapped it on the representations.
Not a question of scrapping. You wanted to be. You said it doesn't exist in your representation. Why am I arguing? I don't want to argue with the councils. It's just that it's pointless. Anyway, you take down then. Will dispose it of?
Yes, yes, my lord.
Yes, Shulai. Who's other appearing?
Lordship, Mr. Pandey is here, Your Lordship.
Yes?
I'm appealing for AICTE.
Now, what do you have to say?
In this petition, we have been made performer responding, Lordship. No relief has been sought against us, Lordship. But I have received written instructions, Lordship. That such kind of disputes with regards to salaries should be resolved at the institution level, Lordship.
SU level means at the level of Polytechnic itself.
Lordship, in the state government, Lordship, because it's because AICTE is not involved in payment of salary, Lordship. So there may be thousands of institutions across the country, Lordship. Such kind of disputes cannot be taken by the AICTE. It's the written discussion.
Where's your affidavit?
No, no affidavit.
We have not filed it.
Already states earlier.
Respondent number?
911.
Who's 9?
AG.
Where's AG? Yes. 1, 2, 3, 4, 5, 6. Number 6 was appearing.
Wait. Thank you.
They are not appearing, my lord. Notice has been duly served. These are the director of the institution. Notice has been duly served.
They're not relevant.
But no, I made them a party. I have some notice, my lord. In spite of that, they are not appearing. Because state norm is, my lord, 5%. I think my learned friend also knows 5% relaxation. And this being under the state control polytechnic, my lord, 5% will come.
The brief facts of the case are that the petitioner was initially appointed as a lecturer in the Shillong Polytechnic Institute in 2004 and subsequently was regularized in the said post. After the introduction of the AICTE capital pay scale in the year 2009, benefits of said pay scale as revised from time to time and incorporated in the regulations have been extended to the petitioner. The AICTE pay scale also provides for opportunities to teachers, including placement under the CAS, before that Career Advancement Scheme, CAS, and also increments for additional qualifications. The grievance of the writ petitioner is with an impugned letter dated 13/2/2024, whereby the respondent number 2 whereby the state respondents in the education department.
Respondent number 3, Your Lordship.
Just right, state the respondent education department.
5, Your Lordship, not number 3, Your Lordship. 5.
No, right, we just state respondents in the education department had where's that letter? 87. Had stated that though the writ petitioner was considered for career advancement scheme, however, as he did not meet the AICTE faculty norms regulation of 1999, inasmuch as he possessed second class at both degree and master's level, he was asked to exercise the option to continue in the existing AICTE scale with no further increments or CIS/promotion, or to revert back to state scale of pay with pay protection of the last pay drawn under the AICTE pay scale. Stop. Mr. S. Sen, Learned Counsel for Petitioner, has submitted that the impugned letter comes in direct conflict with the notification dated 4/6/2016, which had been issued by the UGC in connection with educational qualification, and have drawn attention of this court to the notification dated 4th January 2016, wherein he provides for the relaxation in minimum qualifying marks of 5% for SC/ST persons. Stop. He therefore submits that on the face of the impugned letter itself, the same is untenable, as the writ petitioner belonging to the reserve category shall be entitled to the benefit of the 5% relaxation. Stop. That is your submission, correct? Yes. He further submits that if the learned counsel has then referred to the latest rules of 2019. That is notification dated 1st March 2019 of the AICTE, wherein
31 minutes.
Wherein at point 2.1, the cadre structure and mode of appointment have been given, and he submits that in a perusal of the table appended to the said section or said rule will show that there is no distinction between promotion and direct recruitment. Stop. He closes argument submitting that the petitioner, coming well within the relaxation provided to the scheduled tribe candidates in terms of qualification for appointment, the same, there is no justification in denying his further progress in his career on the ground that he had scored 5%. He had lacked the requisite 60% for completion of the CS. Yes, stop. Next paragraph. Mr. Enduk Leonard EAG with so and so. At the outset has vehemently submitted that the writ petition should be dismissed at the threshold itself on account of material suppression of material facts. And in this context where's the affidavit, has drawn the attention of this court to lecture 4. Lecture 4.
Lordship. Page 21, Your Lordship.
It's not labeled a lecture. To lecture 4. Wherein at page 21. Page 21. Wherein at page 21 thereof a representation which had been preferred by the petitioner and others is contained. Stop. The senior counsel has submitted that the relief sought by the writ petitioner is based on a notification dated 14/6/2013, whereby he was placed in senior grade, and in the said representation the writ petitioner has discredited the said notification by representing that the government is still following the state procedure prior to 27/10/2009 in placing the lectures in various grades provide government notification dated 14/6/2013, which is not in accordance with the latest AICTE notification 2010. This very fact itself, it is argued by the Senior Counsel, makes the writ petition ineligible for any consideration of any relief, inasmuch as by the incident petition what has been impugned is the supersession of the notification dated 14/6/2016 on which the petitioner has disowned. Stop. It therefore submits on this ground alone that petition should be rejected. Stop. Next paragraph. On the other limb of submission, the Learned Senior Counsel has submitted that the prescription for 55% is only with regard to appointment and will not apply in cases of promotion. And though the petitioner may be in service, the fact that he does not possess 60% percentile marks will render him ineligible for even for country under the career advancement scheme. Stop. The options given to the petitioner is further submitted does not suffer from any infirmity, as presently the state scale exceeds the scale of the AICTE current scale. To those submissions, he did those submissions by, he concludes the submissions by, where's the rules you showed for me affidavit? What was motion?
Lordship, Annexure 6 at page 25, Your Lordship. That is
of your affidavit. Number 9. If any infirmity, I get it. Page. Sorry. Page 20.
26, Your Lordship. That a 5% relaxation at clause 4, Your Lordship.
That 5% doesn't have doesn't have 60% time. What is it? For promotion. Learned Senior Counsel has also referred to the notification dated 2016.
Lordship, yes. At page 25, Your Lordship.
AICTE.
Lordship, yes.
Notification dated 4/1016.
Lordship.
Wherein in the table at column number 4, he submits consideration is only for the purpose of appointment and not for promotion. There's no infirmity. The option given is
state scale exceeds the scale of the AICTE.
Current scale of AICTE. In conclusion, the Council submits that the writ petition, therefore, being bereft of any merit, is liable to be rejected. Next, just requires Mr. SN to on the point of suppression that has been alleged by the state respondents as to representation, has submitted that the same has been clarified in the rejoinder, and it is inconsequential inasmuch as though representation had been made, the state respondents had acted upon the same by extending the AICTE pay scales to the writ petitioner, and as such the matter is being a non-issue, no cognizance of yes.
No, what I say, Your Lordship, so far that CAS is concerned,
so
altogether 10 of them, what I say, 10 of them were there. So this was never totally scrapped. So far, those who were recommended for promotion to lecturer selection grade, I was recommended for lecturer senior grade. There were others who were recommended for lecturer selection grade. They were granted as part of that 2013. So far I am concerned, nothing has been granted to me. It was only scrapped, my lord, on the ground of qualification, that 55% mark, by the impugn decision.
So it was never, scale never given to you?
Never given to me.
Till now?
No, never.
It's inconsequential in as much as the AICTE scale
senior lecturer
has been never extended to the
senior lecturer. Never.
AICTE scale prescribed for senior lecturer, senior lecturer has never been extended to him, though granted in the order dated 14/6/2013. There's no time. We'll have to. I'll dictate the remaining in the chamber. The other matters there, because at 2 o'clock we have to take evidence.
Item number 6.
Highly obliged.
Obliged.
Take some time to. Not some time, I mean, because.
My obliged.
Jenny, just give me 5 minutes.
Yes.
Just play my. Yes, I thought Mr. Philemon had to argue.
My lord, he is giving me a chance. I'll take only 2 minutes to clarify. I filed my.
Giving you 2 minutes chance means.
I'll not copy on that, man. I filed my short affidavit regarding the merits of the case. We have brought on record the inquiry report, where it clearly reveals, my lord, that the writ petitioner do not have a cough field. No cough field.
Yes.
Even assuming, my lord, that the writ is allowed and affiliation is restored, but there is no place for the promotion of the golf activities in the state because they don't have a golf course.
Without?
They don't have a golf course. But the course they relied, the golf field they relied is in
there's no
army.
question, there's no hope of mediation. All are golfers.
I don't think so,
They should have sportsman spirit of all those sportsmen.
Here the sportsman spirit has gone elsewhere.
Lacking.
Gone elsewhere.
Who's being unsporting, you or them?
I am already out.
But therefore, the golf field they relied heavily, Shillong and Umroi. It belongs to the army, not accessible to the public. So there is no place for.
Is that a necessary requirement?
My lord,
that they have to have a golf course?
Yes, my lord. Affiliated society, the organization must have a proper golf course. That is one criteria. And secondly, my lord, I have argued regarding whether the activities of affiliation amounts to public function or not. I don't need to reiterate that one. So my humble submission today is, my lord, apart from the argument we have already advanced, in case if lordship inclines to entertain the writ petition, my lord,
Mr. What argued last time that is a public function. We were looking at that. We were looking at that aspect only. Whether the Indian Golf Union and whoever is the Shillong Golf Association, he exercises public functions. Because whether they can be distinguished public functions and private functions, sending players, that's a public function, right. Or holding, trials.
Yes, my lord is correct. My lord is correct. I have argued that, however, all the activities of the IGU is not amount to public function. I have argued over it. Therefore, I would raise my argument by making a prayer. Even if lordship do not want to entertain my argument and accept the writ petition.
Why are you presupposing that the court is not entertaining your argument?
My lord, the practical difficulties would happen. Suppose if lordship
why are you presupposing? When the court has not made up its mind, why presupposing that we're not inclined to accept the argument?
So because to avoid, I will not stand up again. Practical difficulties is that my lord.
Why are you saying that? Why are you submitting that?
Because the lordship is now hearing on the merits of the case. Earlier, I did not touch this issue. Yes. Earlier, I did not touch that issue because the lordship was hearing on the maintainability.
Well, that's correct, yes.
Yes, my lord. So only limited prayer is, my lord, since if they restore the affiliation, there is no place for activities. There would be a problem, my lord. Therefore, in case if lordship entertain the writ petition, my lord, my prayer would be, my lord, instead of setting aside the impugned order, allow me 1 month time. I'll give a proper shock cause notice to him, proper hearing, and pass a final speaking order.
I was waiting for that to come, actually.
My lord, in the meantime, my lord, I
can give you at the most for the IGU.
Yes.
1 week.
That also we can do.
At the most 1 week, then we will.
My lord,
otherwise, we do more submissions. We will pass the judgment.
1 week, 10 days, we can give the proper shock cause notice, pass a speaking order.
Otherwise, no more submissions, we'll pass the judgment.
Well, in that event, they would have to first withdraw that letter.
We will not act upon it.
No, there's no question of not acting upon it. They have de-affiliated me.
But the affiliation order, we will not act upon.
No, they have already acted upon it by my lords affiliating some third party. It's too late in the day to do this.
But that will not take further steps.
That eureka moment has probably come a little too late.
You're not de-affiliated you as yet.
I'm de-affiliated.
No,
and somebody else has been.
I am affiliated.
De-affiliated.
Well, both are correct.
What are correct?
De-affiliate is also there, and disaffiliate is also there.
But as on today, I am affiliated because I am eligible. And
there's a third party.
Just a moment. He's de-affiliated because he's ineligible.
No, but has due process been followed?
No, I'll just come to that.
That comes to that only because why is maintainable? Why we've said to go into the mercy? Because on the question of arbitrariness.
Correct.
Now, whether you see the only thing that why the attention of the court was drawn to that factor only that now they were all along affiliated. Correct?
Yes, ma'am.
Continuing fine, and one fine day there was a sort of internal inquiry or some report which is not privy to and on the basis of that report or something, they have been de-affiliated.
Yes, my lord. And I have been affiliated because I'm eligible.
Okay, we're not quarreling with your credentials. You've been, but the manner in which the disaffiliation was done and affiliation given to someone else, that's the only thing that whether it crosses that Lakshman Rekha line of whether alternate remedy will suffice.
Yes, but that IGU can take care of it, my lord, if your lordships is inclined to.
Because you're limited because you're only the beneficiary, Mr. Nomri.
My lord, beneficiary because I'm eligible.
Exactly, you're eligible. It's like a tenderer. Maybe the L1, so you've been awarded, but you've been dragged into the controversy because of your being successful.
What I'm saying is, my lord, if your lordship is inclined to direct the IGU to give him a opportunity of hearing, my lord, then I also should be heard. I also should be heard. My lord, that is one. That is one, my lord.
Yes.
Now, since April, my lord, since the time I've been affiliated, my lord, I've been functioning, my lord. So, my lord, during this period, let status quo be maintained, my lord. Let me function. If he succeeds, then I'll have to go, my lord. If he succeeds in his hearing,
there's been no stay order.
Yes, my lord. There's no stay order, so let me continue, my lord.
There's no stay order. So
yes, my lord.
There has been no.
There's no stay, my lord, and I've been functioning since then, my lord. So let that continue, my lord.
That we do not need to pass any observations on that or make observations on that. The thing is that I don't think the interim order. No interim orders.
No interim orders, my lord. But there cannot be any void, my lord.
Why is there a void?
Function, my lord.
No one functioning now.
I'm functioning, my lord. I'm functioning.
Then where's the void?
So that should continue, my lord.
You don't need orders of the court for that if you're functioning.
I'll leave it to your lordship.
That's it.
That's it.
Close arguments.
Yes.
Then
three issues.
Both parties should be heard.
I'm sorry, mate.
Yes.
Three issues primarily.
But you already heard you, Mr. Paul.
No, but this issue was never there. What now both my learned friends are saying, they've finally woken up to the reality probably, especially my friend appearing for the IGU. Well, this option could have been exercised by them even while there was currency of this writ petition.
But are you willing to hear them? And in the meanwhile, let them continue.
No, it cannot be, Milaj. It cannot be like that. Why?
Can be a void, like he said.
No, man, Milaj, there's no question of void. It cannot be like that, Milaj, primarily because of three reasons. There is an order withdrawing my affiliation. That's one.
Yes.
In the same day, Milaj, there is an order affiliating some third party. Now, while these two orders are there, Milaj, you cannot sit over a decision which you've already taken.
You mean sit in appeal?
In review. Probably, Milaj, that exercise could have been done, and then they could have come back before your lordship saying that yes, this maybe was
we'll pass a judgment along those lines.
No, Milaj, what I am saying is something a little different.
Set aside those orders.
If those orders are set aside, Milaj, then it's okay. That liberty will be there available with them.
Yes.
But then those two orders have to go.
No, they naturally have to go. If IG is going to look at it afresh, and meanwhile, let status quo continue.
Well, it's that
you admitted that you're not running it so far.
No, Malaj, there's no question of status quo. That it basically, Malaj, is giving me something.
You can't revert back to status quo.
Malaj, it would, if the order is bad in law, Malaj, any beneficiary under that order cannot
pass any observations on whether order is bad or good in law. If that is the situation, since it involves golfers, larger,
Malaj, there's no question of golfers, because now what has happened?
Who's suffering?
Malaj, now what is basically happening is this is something that IGU should have considered at that point of time. Now, after Malaj, they are cornered.
That's water under the bridge, you suppose.
Well, Malaj, after they are cornered, they cannot come back to my lords and say that, okay, very well, we'll look at it again. And Malaj, I cannot be made to suffer because of this. I'm okay with the part till my lords say that let these orders be set aside. If the orders are set aside, my lords, then somebody who's a beneficiary under that order cannot be allowed to continue. That would be an absolute illegality on my part, on me. Now, the one thing I wanted to point out, my lords, and because
it will be like a post facto hearing.
It cannot be, my lords. There cannot be a post facto hearing on a decision that you've already taken.
Yes, my lord. Neither this side or that side, my lord. I will keep the impugned order in abeyance. And my lord, within the 10 days' time, my lord will give opportunity.
Well, this should have been done at that stage, not at this stage.
Water under the bridge, Mr. Paul.
There was no merit.
Well, if it is water under the bridge, my lord, I cannot take advantage of that now. That's what I'm saying.
It's water under the bridge. It's work to your detriment. That's too bad. It happens. Yeah?
Well, your lordships will kindly appreciate two factors, my lords. The process by which that decision has been taken. first, my lords, I'll just bring this to your lordship's notice. I had submitted this at the first stage that I had requested, my lords, that they bring the records before my lords.
Has been using multiple times the word defunct against me. As on today, my lord, he is defunct. All his members have resigned, my lord.
Not all.
All the members.
Arms can be twisted in many ways. Arms can be twisted in many ways. Arms can be twisted in many ways. That's what I'm submitting before your lordships. I had submitted this before my lords. The manner in which that decision was taken. Your lordships may kindly have a look. We have got these records. These are part of their records, which I had submitted earlier. If my lords would recollect, I had said that please bring these records to the notice of this honorable court. How that decision was arrived at. And even after filing 2 affidavits, they have willfully suppressed these facts before my lords. Now, first, my lords, I'll point out is the, my lords, this is an email dated the 9th of April from this very person who is, my lords, now swearing affidavits before my lords, Major General Bibhuti Bhushan. And before that, my lords, may kindly have a look who's sworn the affidavit now.
Where's the email?
This compilation I've just given before my lords. First, my lords.
9th April.
9th April, my lords. It's down below. Major General, kind regards, Major General Bibhuti Bhushan. Yes. Now, what does it say, my lords? The next governing council meeting has been planned to be held on the 26th of April 2025 at 3 p.m. The venue of the meeting is JP Resort, Noida. The meeting will be followed by dinner, stay, so not relevant, my lords. Agenda points for the meeting shall follow soon. This is the relevant part. Now, next page, at page 2.
Where did you get this from?
Well, these are part of the official records of IGU. We've got it from the rest of India.
Okay.
Now, DG emailers again writes on 14th of April, dear all, please refer to the earlier email dated so-and-so, and this is the agenda for the meeting on the 26th April 2025. Now, my lords, may kindly see whether affiliation or de-affiliation of the state body of Meghalaya is an agenda item here or not. It is not there.
It's referred to this meeting 26th April.
My lords.
In de-affiliation.
My lords. Because this is the agenda for the 26th April meeting. Now, what they have brought before
Any other point?
Yes. Any other point, my lords, can it be taken as any other point? It's not as any other point. I'll take that also, my lords. My lords, may kindly come. This is what they have now annexed. This is a so-called report of 20th April 2025. My lords, have it at page 3.
Yeah.
Now, down below, my lords, it says on 16th of April 2025, Honorable Treasurer so-and-so conducted a recce of the Meghalaya to check the credentials of the golf courses that are affiliated to the Meghalaya Golf Promoter Society. Our findings are as follows. This they have annexed. Then recommendation, my lords, is at page 3A. It says, in light of the above, it is recommended that the Shillong Golfers Association be granted affiliation to the Indian Golf Union and the affiliation to MGPS be withdrawn. Now, this is the recommendation. Now, at the next page, my lords, are the minutes, which I had submitted in the first place, my lords. My order is a culmination of what has happened in the minutes. May kindly see, this is dated the 26th of April 2025. And, my lords, we will come to where the relevant portion is. There's a very interesting expression is used here. Sorry. Now, at serial number 11, my lords.
Yes.
Visit to the northeast. Meghalaya SGA compliance report by so-and-so. Shillong Golf Club is the only 18-hole golf course. Gorakhnath is so-and-so. Decision. My lords have seen decision. Shillong Golfers Association will replace the Meghalaya Golf Promoter Society as the recognized state golf association. And, my lords, pursuant to this, the impugned order is now passed in as against me, saying that withdrawn with immediate effect. So what I'm trying to say is, it was not even an agenda item.
We understand. That just adds to the arbitrariness of what they've. That is why Mr. Changreso said that.
My lords, so then in that event, my lords cannot give them a handle, my lords, to continue with an arbitrary act. Once it is proved beyond any doubt, my lords, that an act is arbitrary, any beneficiary under that act of arbitrariness.
Under the stewardship of some other, who will do it in the meanwhile?
Well, we've been doing it.
See, we cannot add more, what do you call it, into this controversy.
My lords, there is no controversy. That's what.
Neutral body. Then.
My lords, I am saying if they have to behave like a
10
neutral
days.
body.
10 days. You decide in 10 days. Yes, and we'll pass orders.
Well, my only prayer would be that there cannot be somebody once an act of illegality and arbitrariness is established.
Who's the golf captain?
So somebody, I think somebody by the name of Mr. Anil Pargal is the golf captain.
My lord, in the absence of a proper affiliated organization, the IG used to nominate the ad hoc committee, and an ad hoc committee look after.
That's why I was asking who's the golf captain.
Yes, like so within 10 days, my lord.
The golf captain belongs to which club? To which?
Shillong Golf Club.
No, Shillong Golf Club.
Now, very
association.
Shillong Club. Now, very interesting, my lords, their affidavit. Now that they have, my lords, not taken your lordships to the affidavit filed by the Shillong Club, I'll take your lordships to the what is the affidavit filed by the Shillong Club. My lords may have to look at have a look at it. This is, my lords, the affidavit which is filed on 8/7/2025.
My affidavit.
Yes, your affidavit.
Let me argue my own case.
No, I mean, we'll not hear any further arguments.
I'm just placing, my lords, who are they? My friend has now chosen, my lords, not to argue it. 8/7/2025, if my lords have a look. My lords have it.
In that case, Lord, I'll place my entire affidavit.
See, if the parent body, which has taken a decision in principle to hear,
my lords, where is that decision? It's a submission made off the cuff. It has to come by way of an affidavit, or that action would have by now been completed and come before your lordships. They chose to, my lords, contest this matter for the last 4 months. Now, when they are cornered, then they say, okay, very well, we will take a fresh decision in the matter. But, my lords, till that extent, at the same time, they're not abandoning it. Let my learned friend concede before this honorable court that the order is bad in law.
My friend has misunderstand our stand. Our first stand remained the same.
If, my lords, I cannot blow hot and cold. I cannot blow hot and cold. If I'm saying, my lords, that I'm sticking by my order, then that liberty cannot be there. I cannot seek liberty in the same breath.
Yes.
And, my lords, who's the Shillong?
To file affidavit to show the golf course, they will never show.
My lords,
they don't have a golf course. That
my
is
lords, I don't understand.
We're not going to go there.
My lords, I may only ask myself a little question. If your lordship just permit me this one question to ask.
Yes.
My lords, Shillong Cricket Association or Meghalaya Cricket Association, does it have a cricket field? It does not. It's an absolutely ridiculous argument, if I may use this expression.
On the memorandum of association.
I'll take my lords to the memorandum of association. It's not a requirement under their own, my lords, bylaws. It is not a requirement. And I pointed this out. It is not a requirement. They say a golf club must have a golf course, but a state golf association does not need to have any golf course, because it is an association which deals with the administrative things. It is not on day-to-day play. Now, Shillong Club's affidavit, my lords, may kindly have a look at it.
Shillong Club is not a party.
But Shillong Club has filed the affidavit.
Shillong filed the affidavit, how?
Because, my lords, they say Shillong Golf Union or Meghalaya Shillong Golfers Association is a unit of Shillong Club. Now, that is why I am trying to bring it to your lordship's kind notice.
Respondent number?
Well, this is filed by respondent number 4.
Yes.
Now, they say, my lords, kindly have a look. They say, my lords, the answering respondent states that Shillong Club Limited, established in 1878, is amongst the oldest clubs in India and is credited with founding the Shillong Golf Course, a historic venue.
Where are you reading from? Para?
Page 2, para 3.
Okay. Yes.
My lords have it?
Yes.
Shillong Club, my lords may kindly take a note. Shillong Club Limited was established in 1878, amongst the oldest clubs in India and is credited with the founding of Shillong Golf Course.
If I understand, no.
I haven't started arguing.
See, the thing is that we'll not go there now. We'll not go there, Mr. Nongri. Thing is that is Shillong Club owns our golf course and they established this.
Yes, this is my affidavit, my affidavit.
So it's Shillong Club which is the owner of that golf course. Now what is being argued by IGU is they don't have a golf course. They don't have a golf course. Shillong Golfers Society also does not have a golf course.
Okay, the thing is that let them decide.
Correct.
In fact, yes, we'll pass orders.
Yes.
I am only saying, my lords, in that event, and my lords may kindly take note of the
submissions that, we'll record submissions of Mr. Changreso that IGU is ready to re-examine the matter under orders of the court, the matter, and to allow, and to examine matter afresh. Okay, and that's your submission. 10 days.
My lords, but in that event, if I may just add over here, if they have to examine it afresh, the orders that have been passed by them.
But not allowing you to take over, not allowing them to run also. That's it.
No, I'm not saying that. I'm simply saying, my lords, that de-affiliation has to go.
That will go.
De-affiliation has to go.
The orders will go, but no one will be allowed to run. That's all.
I am not saying anything, my lords. I am just stopping at the point where I'm saying that de-affiliation has to go.
It will be taken from the point of where it stopped. That's all.
Well, the point is that there was no point of inception over here. If that's why I pointed out in that compilation, my lords, that if it is part of something, then naturally there would have been this process. The only reason
you've shown that even they have realized that maybe it's decisions in case without the decision making process is something wrong with it. That is why it's been attracted, the what do you call it, discretionary. Maybe excited for under 226, that's all. Simple. Otherwise, you have the Rule 66, arbitration is a bilateral agreement, the bilateral arrangement between the parent body and any association. And so, if that you go under that Indian Olympic Association has that Council of Arbitration is there.
True.
So that is, you see, it will go there. So this dispute might land there. God knows.
No. That is if that procedure had been followed. Maybe yes.
Exactly. That is one. So
because if your lordships will first recollect that, well, it's my first response to when it fell from your lordships about the arbitration, I had said that I am de-affiliated. Once I'm de-affiliated, my lords, that clause cannot apply to me.
No, but current law says otherwise. Even if you're de-affiliated, if it comes, it stems from that relationship, even though you're out of that. Otherwise, then you say that if in a contract I've signed, suppose I enter a contract, I've signed, my contract is terminated, the contract doesn't apply anymore to you.
No, it's not that.
You have recourse to arbitration.
But that in my humble submission would not.
There are decisions. In fact, I've done some research.
That would not be a parallel.
Whether arbitration will be open, it will very much be open to you. Even if you're de-affiliated.
No, it is. I had pointed out my submission on that was on twofold. One was that I was de-affiliated.
Arbitration clause go beyond the contract strict terms.
True.
Okay, your BOQs, whatever, it'll go beyond that.
True.
So the thing is that arbitration recourse will be available to you.
True, my lords. Yes. But then the language of that particular clause, my lords. The language of that particular clause would not apply to me.
It will be available. Yes. Next matter.
So my lords,
thank you very much.
My lords are reserving it for judgment.
Yes, we'll pass it by Friday. Or by, to tell you the truth, see, the judgment is already prepared. But now due to this, that's why. But I just realized that when the judgment I touched, on this point on mentability was over. So then I realized that I had not given this point number 4 a chance to be heard on this mentability, apart from mentability aspect. So that is why after I reserve a judgment was very pre-pronounced, then I realized the mistake on my part. So that's why I had to fix it again. And so then it's good also that this has come to.
This could have come at the first instance. Yes. We would have saved all of us a lot of trouble.
Release 14.
Yes. The respondents, bullet points?
My lord, I have already submitted, my lord.
When?
On 24th June. What? This code was not available that day, but since the direction was there, I have already submitted, my lord.
Any more submissions to make?
No, Your Lordship.
A brief clarification. The Lord Counsel for the petitioners had referred to a judgment, which I had also referred to, but he had sought to distinguish one passage. If your Lordships will just have the judgment of the Meghalaya High Court, which your Lordships had authored, Amanda Basaimot. Lordships had referred to a judgment of Union of India versus Tarsem Singh. There's just one line that I want to bring to your Lordships' kind attention.
Where is the judgment? Oh yes.
Amanda Basaimot, rendered on 6/3/24.
Yes.
Please have page 12.
Yes.
So in para 10, my lords, had referred to a judgment of Bichidananda Behara, where they had quoted another judgment of Union of India versus Tarsim Singh.
Yes.
If your lordships look at the next page, para 13.
Yes.
What it basically says that in the event there is a continuing cause of action.
Where is that?
I'll just read out the at page 13, the third line, my lord. But if the claim involves issues, but if the claim involves issues relating to seniority or promotion, etc., affecting others, delay would render the claim stale, and the doctrine of laches limitation will be applied. Insofar as the consequential relief of recovery of arrears for a past period is concerned, the principles relating to recurring successive wrongs will apply. As a consequence, the High Court will restrict the consequential relief relating to arrears normally to a period of 3 years. In our case, the claim is sometime from 2005 or 2007. And this has also been referred to in another judgment that I had relied upon. This is the case of S. Lalitha versus Union of India, 2025, SEC Online, SC 916. I have referred to that. It's there in my notes as well.
Which are bullet points, MS Langsti? This is the one?
Yes, Your Lordship.
This is the one?
No, theirs is a thick compilation.
Your Lordship, there's a compendium. Your Lordship, we had forwarded you a compendium.
Compendium was a compilation.
It's almost the same, Your Lordship.
Then?
I suppose it's just a bit thicker.
Depending on the size.
Your Lordship, that's just my opinion.
Yes. There's a bullet.
Your Lordship, we have not received the bullet points from the government side as well.
We have already on the 24th of June.
They have received.
Not bullet points, it's
You give it to them.
Have you given us?
No.
You have given the arguments to them also.
Last time I remember we had given them 1 pages we had forwarded every time we give our arguments, Your Lordship.
Last compilation, no.
So I have received. I have been served.
Then fine. You are paying for whom? You seem together.
No, they're for the state. I am for MTDC.
Yes, bullet points will receive. The hearing is concluded. Reserved for judgment.
Much obliged, Your Lordship.
16.
Please, Your Lordship. My lord, this is, I have certain instruction. This is regarding my lord determination of seniority between Vice Principal and additional STSU. Now, my lord, I have received the instruction from the government. Government is trying to look into the matter. So, in this situation, my lord, they want to withdraw the case, my lord, with a liberty to file afresh.
Well, Mr. S.R. Sen, the petitioner submits that due to certain developments which are yet to crystallize, however, the petitioners pray that below to withdraw the petition with liberty to file afresh. So advises. On side submission, matter stands closed on withdrawal. However, liberty has played this.
17.
Yes.
Lordship, this is an admitted case of the respondents that my land has not been acquired and compensation has not been given on the land, Your Lordship.
Admitted case of the respondent. How to state that on affidavit?
Lordship, it's on affidavit. Now, Lordship would also kindly note, Your Lordship, that the violence of this Narrow District Regulation 1 of 1964 is under challenge, Your Lordship. The matter has come up yesterday, but it was adjourned, Your Lordship, which would have a bearing on this district case, Your Lordship. Because it pertains to the right of way, Your Lordship. Now, this has come in view of this regulation. Otherwise, Your Lordship will kindly know that this, even in their section 11 notification, it becomes very clear, which is in my petition, Your Lordship. If Your Lordship is pleased to us to an initiative of my petition, Your Lordship. Lordship starts on page 27.
Yes.
Lordship will kindly note that it is only parking land which is been acquired. Now, Lordship will kindly note parking lands are not private property. It is client property, Your Lordship. Now, for which the NOCMA is the custodian, Your Lordship. So without the consent of the dogma of a particular acting, your lordship, land cannot be transferred. Whereas in the instant case, your lordship, the Garus District Council claims to have issued pattas with regard to these lands. Now that is under challenge in another petition, your lordship, for the district bench. Whether the district council can issue pattas with regard to lands.
Yes.
So in view of this, your lordship, because both those matters are before your lordship, and would have a serious bearing on this issue, your lordship.
Now the only one thing, MS Paul, let's see your prayer. 1 second. Where's the representation put in by you at that time against the notice, date 15/7/24?
Lordship, this is a joint.
No, this is.
Lordship, we have filed a joint objection. That is another aspect of lordship that is not considered an order, not for which I could have come under section 64. But why I am saying, your lordship, the two matters pending for the district bench would have a bearing on this is because of this larger issue of whether the district council can at all issue a patta with regard to acting lands. And admittedly, these are acting lands which your lordship will not be required. At the same time, he also gave the same report and says that my land has not been acquired and no compensation can be given on the land. That's what happened at your lordship.
Now there's a patta issued to you. This is the specific land. This one at Nature 1.
Patta is issued by the district council.
That this is in your name. Correct.
Lordship, it is in my name.
This is in your name, correct?
Yes. Lordship. But the district council claims, your lordship,
That is part of Aking land.
Lordship, it claims, your lordship, that the right of way was mentioned in the patta itself in section 4. In clause 4, your lordship. Now, our stand is that, your lordship, the Garus Autonomous District Council has no authority in the first place to issue pattas, your lordship.
Yes.
And when the same has been acquired, your lordship, if at all, then it has to be in the concept of the normal, which in this case is not there, your lordship.
No. Just come back to your patta. Your case is that this is the patta or the for your land, correct? Yeah, this is part of Aking. This patta issued to you. You have to be clear on that. No, you've come with this patta now. Just listen. So this patta is to establish. Let's see what you said, lecture 1. This is to establish your ownership of. To show your. Yes. Yes. Now you say that the notification mentions the Akings and not your land, correct?
No, lordship.
Then?
Lordship, page 27 mentions the Akings.
Yes.
Now, there are all these different Akings. My land comes under the Meghalaya Aking, lordship. My land comes under Meghalaya Aking. So page 28, your lordship, will show that these are the lands under this Meghalaya Aking. So I am under the Meghalaya Aking, but for which, by issuing the patta, the Garus Autonomous District Council claims, now I am bound by this regulation, your lordship, which allows for this right of way, for which I am not entitled to any.
Number 16. Yes. Oh, now, so it comes like this now. You saying that this patta, it establishes not your title, your occupation over this land. Okay, fine, number 1. Number 2, now you say that this notification issued, namely Akings, and your name is shown at number 16.
Lordship.
That means your land within the Aking itself.
Page 27, lordship, shows the Akings.
Right, no, page 28 shows your name.
Lordship, this is a huge notification. So I
No, page 16, see, page 16, at para 16, will it refer to the land given in the patta to you? At C number 16 where your name is shown, is Victrola Sama, correct?
Lordship.
It refers to that land.
Lordship.
Then
But
where's the
this is
quarrel then?
admitted to the acting land.
Then why did you take a patta?
Lordship, this is generally issue for everybody, your Lordship. Now, the larger question before your Lordship is, can district council issue patta?
Larger question, we understand larger question. We understand larger question, but what this court can't understand, can't correlate is that now you've come before this court annexing a patta which is granted to you in this aking, correct? And your name has been shown also in the section 11 notification at number 16. Okay, section 11 notifications, the preliminary notifications given, that gives you scope for objection, so on and so forth. Now you are changing a stand, or your stand now is that even my patta is wrong because this council has no authority.
My stand, your Lordship, the council of the Northern before
Yes, okay, yes. They say that, so that means no reliance can be placed on the patta also.
Lordship, what is
See, only court trying to understand one thing, MS Paul, just listen. Whether you before this court, for this particular piece of land for which you hold a patta, has been taken over for increase of the ROW or widening the road without payment of compensation to you. That's the only thing. So we thought that we were on that list, that look, my land is here, is my periodic lease patta, and so from occupancy rights or ownership rights, I should be compensated. That's the only thing. And so if it is found that yes, that your name's in the list and they cannot show anywhere that you've been compensated, and orders will follow for the collector to do necessary thing, inquiry with regard to whether this compensation for this piece of land has been released. Now the larger picture, you say that they can't issue pattas now, that takes it to a different level, which in single bench we can't handle it. See, so we close the hearing for now. You want to wait outcome of that within bench matter.
Lordship, otherwise, Lordship, I will be directed under 64 to approach the collector. But if I approach the collector, Lordship, my case is that my land has not been acquired.
See, 64, it is quite wide in this application.
Lordship.
So even if it should have started from section 15. The thing is that if any notification comes out, if you agree in any manner, whether you have interest in some piece of land, which there are notifications been issued, under 15 you can go and you file your objection to section 11 notification, and the collector will have an inquiry, he'll examine here, then he'll generate a report, which should, and if it goes a step further, whereby compensation has been apportioned and awarded, payable to whom, whether it's payable to you or not, then 64 will come in. But now now Mr. Sen, has any compensation been paid to anybody in this
no,
list?
Because they fall on their lands fall under ROW, so they're not entitled to any interest over the land.
Then let you wait then for the outcome of the division bench.
My lord, I would submit there is no nexus, and this has been decided by a coordinate bench. I'll just take your lordships through that.
Coordinate bench means bench of Justice B. Barasaji.
Yes, my lord.
Yeah, that judgment may
from the same bench, same subject matter, same objection. She's a signatory to the identical objection, lords. So, your lordship, just give me a minute. I'll just show your lordships the facts.
Yes.
I have no quarrel with that, your Lordship.
Where the judgment?
This same issue was raised by them in the other court as well. But my lords will just take notice of a few things. The section 11 notification was issued on 27th of June 2019.
This here in
this case, yes, my lord. They are similarly placed with the other writ petition which was disposed of by Justice Bharjarji. My lords, the section 11 notification issued on the 27th of June 2019. There against, they filed an objection on the 5th of September 2019. The objection is at page 29 of the writ petition.
Yes.
If your lordships have that objection.
Yes.
What they've basically raised in this particular objection is that they are entitled to adequate compensation. That's all. And they've raised an issue with regard to the ROW. Now please see the signatory at page 30. There are several people. The petitioner's name features at serial number 2. Now the rest of the petitioners had preferred a writ petition before this honorable court, and an order came to be passed in that. And if your lordships will have my affidavit filed by the state, that is the respondent number 3.
Yes.
That judgment is at annexure 11. I apologize, page 11 annexure 2.
Yes. So then, MS will allow your prayer, you go under 1664.
Lordship. And there is no, well, it's the prayer in this writ petition, what they're asking for is to set aside the quit notice. That's all. None of the notifications, the statutory notifications are under challenge.
Doesn't matter, she can take it afresh.
Yes, under 64.
Pass orders, yes.
Lordship, Lordship.
We'll give you liberty, we go under section 64.
And may I just also point out, earlier today, your Lordships had disposed of one matter. They're from the same particular area, same Aking land.
Yes.
But the larger question has a bearing on this,
Of course, then that'll be open to the petitioners to agitate the relevant point of time.
Lordship, just kindly note this. Lordship, the state is already on record saying I am not entitled to any compensation nor is my land being acquired.
No, that is not what we've said, madam.
See, one thing, MS Paul, you go on a 64, because even today also you pass a judgment, on the same aspect. Yes.
18.
Yes. Anyway, we'll pass orders.
18.
Obligation.
Lordship, only in this connection, Lordship, I am referring to the BBMD case, 2022 STP 569.
2022?
2020.
Okay.
I'm aware, my lord, the facts are very different, and this I'm referring to this judgment in that case.
Because here admittedly also my land has been taken without being acquired, without being compensation. So is it similar like that?
So this is on the question of delay, my lord.
No, I'm not on the question. I'm on that.
No, my lord, I'm on my judgment. My judgment is on the question of delay.
Yes.
I'm on paragraph 12.3.
Yes.
Because the right of way amounts to taking away my land without giving me any compensation and without the land being acquired, Your Lord, which cannot be.
Only there is stay order. Stay order.
Yes. 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 Next matter.
18.
In this matter, whether the conducting council also is on leg, my lord.
He's behind you, I think. Mr. Kumar. Yes. Yes, Mr. Kumar.
I'm sorry, my lord.
Yes.
My lord, this is the second round of litigation, my lord.
Yes.
Earlier order, my lord, kindly see page number 24 annex 8, my lord. Matrix the motion matter, my lord, the non-communication of PCR. And the relevant portion is at page number 27, my lord.
Yes.
Paragraph 8, my lord, it is further directed that should be entries be upgraded in consideration of the representation taking into account the petitioner's earlier track record, the respondent authority shall constitute a review DTC for grant of consequential reliefs, if any, on the basis of the above. The entire exercise shall be completed within a period of 6 months, my lord. Then thereafter, my lord, the petitioner has submitted the detailed representation in the next, my lord, page number 28, annex 9, my lord.
Then what happened?
Thereafter, my lord, the speaking order, that is page number 32, annex 10 was passed by the respondent authority mechanically, my lord. Without any reason, and without considering the entire record of the petitioner, my lord, just they have passed a speaking order, and the relevant portion of that order, my lord, kindly see page number 35, my lord.
Para?
Sorry, my lord, kindly start from page number 34, my lord. 34D in the bottom, my lord, D.
Now one thing, Mr. Kumar, you have a type copy. Your type copy is only up to half type copy given.
Up to page number 35, my lord.
No, see 36 a type copy.
36 is the type copy, my lord.
Of the order itself.
But Yes,
What is incomplete?
It is up to the paragraph number, it is up to the paragraph number 8, my lord.
Why immediately up to number 8?
7, 8.
There are 9, 10, 11.
Up to the 9, 10, 11. Paragraph number
1 and a half pages is missing. Yes. Yes, you read what D? D, you want to read D?
Yes, madam. D,
Yes.
E. It is both mentioning that the petitioner was assessed on his ACR by 7 different officers during the year from 2014-15 to 18-19, leaving hardly any scope of privilege in assessing his performance. The award of high average grading in the continuation period from the year 14-15 to 18-19 clearly reflects that the performance of the petitioner was not up to the mark for consideration him in the next rank, my lord. Then word E, on basis of the annual confidential report profile of the petitioner from the year 1997 to 2022, it has been revealed that he has been graded average grading in the year 2004, 5, 6, 9 and 10 in the rank of Havildar, high average, and in the year 2021 in the rank of Naib Subedar, purely based on his not up to the mark performance during entire service period, my lord.
What about 10? Don't understand it. What does they say? High average?
High average, my lord, only 5 points has been given in his ACR, my lord.
The high average is not 5 points. Average will be 7 points. Average will be 5 points. Read para 10, I can't read it properly also. So small letters. Mr. Kumar, you kindly supply a type copy of these 2 pages to your local council.
I will provide.
Yes, Mr. Kumar, please, I will have to file type copies of the missing part of the impugn order. Yes, before the next date. Just after 2 weeks. You kindly supply it. I couldn't read the Parachana.
19.
Fully accept the office. Registry should be more careful also. We check that half annexure only. Who's for the petitioner?
Miss
19.
What's the matter about? No time. Yes.
Your Lordship,
This is medical disqualification, my lord. Recruitment.
Yes, what happened? What are instructions?
Instructions I placed on the last occasion, my lord.
Where's the petitioner? This after 1 week. Yes. None appears on the
Your Lordship, kindly pass over after lunch.
After a week.
After lunch, we are having election petitions. We are taking evidence. Sorry, we'll have to put it next week. Yes.
21.
Okay, Lordship.
21.
Yes.
In this matter, Lordship, we were supposed to file the rejoinder, Lordship. We have served the advance copy, Lordship, to the respondents. We are filing it in the course of the day, Lordship. We'll serve them, Lordship.
Mr. S. Chanda submits a rejoinder is being filed today itself. It's a matter of hearing after 1 week.
Lordship.
22.
Your Lordship, I pray that this matter may be adjourned for the day Mr. Shulai is on next, Your Lordship.
After 1 week, yes.
Obliged, Your Lordship.
23.
Lordship, I have similar prayer.
Why?
Lordship,
That is Chanda.
Mr. Chanda.
What's Mr. Chanda's age?
Age?
Must be 60 union.
60? I think it's
No.
65 plus, one.
But he's not maintaining good health nowadays. He's not maintaining good health nowadays.
His wife is very
Even
unfortunate.
Yes, on the premise, I don't know, put this matter for 2 weeks.
Lordship, only interim order is to be continued.
Interim order continue. Last one to Manipur, why?
Lordship.
Oh, tambah dekat stream. Kerja tu buat ni tu kan? Oh. Pergi ni mana? Oh, ni buat ini tadi. Makan dalam stream tambah record. Kamu stream boleh record dekat. Have you done more?
Kena 1 week.
1 week number 2, 22.
1 week kan. Pasal nak kan kan ujian petition. Petition macam
Apa? Dari sini.
type ni.
Type ni.
Tu lawyer rupanya ni.
Budaya usia ni.
Ini dia sekarang ni.
Ha.
Long tu macam tu cakap dia.
Tu siapa ni soal type?
Tu dia bilang tu. Tai kalau you supaya nak teh.
Ha. Makan ni kamu stream tak kamu ni.
Aku berbuat type ku berbuat type mainan ni.
Berbuat type ni upet tak type.
Berbuat type mana detektif.
Bukan kuliah nang ni yang kata type. Berjubah perlu type ya kata.
Oh, long kamu sama atau adon kayak cuma kali. Kamu adon.
Oh, hai dari.
Emang anak show tentang apa itu cara kamu nak kopor.
Ini misuan show.
Ngasih ngelak aku ni.
Ha tu.
215.
Tu. Isa boleh atau isa?